The process of mediation, not as formal as going to court. You'll have a mediator. Could be in our case, we have Florida certified circuit civil mediators, and it could be a retired judge. Our attorneys who decide to become mediators by trade, they have nothing to do with the case. They're neutrals, and they are retained by the individual parties. Both parties, in some cases, have to agree to hire the mediators, and they are paid separately. The good thing about the mediators, they're not there to give legal advice. Mediators' role is to attempt and work with both sides to try to arrive at a resolution. The benefit is that the mediator is confidential. Unless you tell the mediator to share information with the opposing side, the mediator will not share that information. The mediator will not provide legal advice. The mediator cannot be called to testify at trial. But the mediator's role is to really help you get to a resolution. Initially, when you go to a mediation conference, by that time, the attorneys have actually provided the mediator with a confidential mediation summary. We prepare that before the case, provide the mediator some familiarity with the case and our position, whether it's plaintiff or defense. The opposing side will do the same. So by the time the mediator comes to the session, whether it's in person or via Zoom, the mediator is familiar with the case and the parties. The mediators first will have an opening statement, will have everybody in the same room, and the mediator will talk at the mediation rules. Generally speaking, mediations are confidential. Saying is what happens in mediation stays in mediation. And the objective is to encourage parties to have an open dialogue on how to resolve the case. Then after he allows the party who's in this case, bringing the lawsuit, the plaintiff, to have an opening statement, and the plaintiff's attorney will have the opportunity to address the opposing side, which is very important because it's perhaps the only opportunity other than trial or deposition which the attorney will have the opportunity to address his client's or her client's position to the party. The other party will also have the same opportunity to present his or her case to the client, to you. Then after that, we break up in what is called caucuses. In the virtual world, you go into a Zoom room, or in your live in person, you go to a separate conference room. The mediator then will go from one side to the other and try to discuss the pros and cons of the case, strengths and weaknesses, and the mediator will basically bring offers and counter offers, and the mediator will suggest and will come up with creative ideas to try to resolve the matter. Two things can happen in mediation. Either the matter gets resolved, and if it gets resolved through a compromise, then parties will sign a settlement agreement, which is signed right there at the mediation conference. If there's no agreement, the mediator will then disclose what is called impasse. The mediator will basically file a report with the court saying there was an impasse, and then the parties can continue litigating. For the most part, it's a fairly informal process, but there is some formality as to the rules, and it's more cost-effective to have a full-day mediation than having a 3-day trial. So I'm a firm believer in mediations, and I highly encourage it to my clients when they're in a legal dispute.